While hearing the SBI versus Rajesh Aggarwal matter, the Supreme Court decided today that borrowers must be heard before banks declare their accounts to be fraudulent. Now, the Supreme Court noted that the classification of accounts as fraud results in serious civil consequences for borrowers and amounts to blacklisting of the borrowers. The court said that the borrowers must be heard under the master directions on fraud. Now, this is being seen as a huge setback for banks that use a central bank circular to classify frauds. Now, declaring an account fraudulent carries a serious civil consequences as per the CGI. The Supreme Court upheld a 2020 order by the Telangana High Court that was challenged by the centre. As a result, under the Reserve Bank of India's Master Circular, banks must provide borrowers with an opportunity for hearing. The court emphasized reading the audi alteram partem principle, which means hearing the other side with the Master Circular. Well, my colleague Harish is joining us on the phone line to give us more details on this. Harish, the Supreme Court has now sided with the borrowers, and it has very clearly stated that it is important to hear the borrowers first before, declaring their bank accounts as fraudulent. Give us more details on this.
Yes, very significant Supreme Court judgment as far as declaration of certain bank accounts as fraud is concerned, and has huge implications on banks and also borrowers. Supreme Court has very clearly said banks must give opportunity of hearing to borrowers before classifying their accounts as fraud. Supreme Court holds that an opportunity of hearing must be given to an account holder before the account/borrower is declared fraudulent under the Reserve Bank of India's Master Circular of 2016. Supreme Court had affirmed Telangana High Court views and overruled the contrary view taken by the Gujarat High Court. Supreme Court held borrowers must be heard before their accounts are classified as fraud. The court held that principles of audi alteram partem must be read in the circular issued by RBI. On the classification of bank accounts as fraud accounts, the bench noted that classification of accounts as fraud results in serious civil consequences for borrowers, amounts to blacklisting of borrowers. Hence, opportunity of hearing must be granted for the borrowers under the master direction on fraud. Therefore, the opportunity of hearing must be given by banks to the borrowers before classifying their accounts as fraud under the master directions on fraud. Such decision must be made by a recent order. It cannot be presumed that the Master Circular excludes the principle of natural justice. A bench comprising Chief Justice D.Y. Chandrachud and Justice Himakoli upheld judgment passed by Telangana High Court in December 2020, which held the same. The bench also set aside a judgment of Gujarat High Court, which held the contrary. So, a very big view from the Supreme Court that banks must give opportunity of hearing to borrowers before classifying their accounts as fraud. Back to you.
Right, Harish, thank you for giving us those details. We will be discussing more on this. At this point of time, joining us is Advocate Vineet Dikshit, is a senior lawyer. He's a Supreme Court lawyer. Mr. Dikshit, I start with you. I ask you the point where the Supreme Court very clearly has said that the borrowers must be accorded hearing before classifying bank accounts as fraud. What are your thoughts on this?
Priyanka, the Supreme Court is absolutely right in issuing this order. There is a basic principle of administrative law, which is audi alteram partem, which says that, the opportunity of hearing must be given to a party. Now, the problem here is that the borrower is now basically virtually blacklisted by this kind of a master circular of RBI or SBI, and therefore the Supreme Court has actually made it clear now that whenever this master circular or this type of a classification is made, then this master circular must adhere to the basic rule of administrative law, which is that, one must be heard before giving an order. So that is what the order has been given, and in this way, Supreme Court has actually upheld the Telangana High Court order also previously, and so therefore, this would actually be a welcome move for all those borrowers, because you see, Riyanka, what happens is that once you are kind of blacklisted, then you have no access to the institutional funds, and your whatever your business or whatever fruitful economic activity you are doing as a borrower, that is hampered. So this is what are my initial reactions to the Supreme Court's order.
Right, Mr. Dikshit, those are your thoughts. And at this point of time, I've also been joined by Professor Sriram Khanna, is a managing editor, Consumer Voice magazine. Thank you for speaking with us, Professor Khanna. Do you see this as a setback for lenders and a win for the borrowers? Of course, because there will be no order that will be given out without a reasoning if required as per the Supreme Court, because it is very clearly stated that there has to be an opportunity given to the borrowers.
I think we should welcome this judgment of the Supreme Court, which gives rights to borrowers. Lenders always take unitary action. They will send an adverse report to the credit rating agencies so that the credit scores go down behind the back of the borrower. They will do many other things unilaterally, even debit accounts unilaterally. So it's a good thing that on this issue of classifying accounts as fraudulent, based on a master circular of the RBI, it has been held that the borrower must be given an opportunity to be heard, and a speaking order should be passed on the issues he raises. This will give every borrower a proper opportunity to explain his side of the case and seek an order on the pleadings he's going to make. And I think this is welcome. And I have a feeling, I have not seen the judgment so far, but if the Supreme Court has held this regarding a master circular in regard to lending by banks to borrowers, then I'm sure there are several other master circulars in which there will be identical or similar or lookalike situations in which borrowers can claim that you should be heard before any adverse action is taken. So I think it is nothing to do with victory or defeat for anybody, but it makes the relationship between the banks, financial institutions, and borrower somewhat fair and balanced, so that the lenders have their rights, but they cannot trample upon the basic rights of the borrowers who are citizens and who have constitutional rights. And it is correct that the Supreme Court has spoken in favor of the borrowers. Thank you, Priyanka.
Right, Professor Sriram Khanna and Advocate Vineet Dikshit, thank you for being with us and taking out your time speaking to us on this important and significant development that has taken place by the Supreme Court, being big relief for the borrowers and probably a setback for the banks there.